Next one. And beyond Banks' Goodfellow, which was a 19th century case, surely there are other issues that arise, and a group of us have looked at this, and there are other issues that are worth probing if there's a question of capacity. Knowledge of prior wills. The issue of consistency is important in my view, clinically. Somebody who's capable can hold a consistent view. Somebody who's constantly changing their views may be considered incapable, and that may sometimes be a reflection of incapacity. Too easily influenced, unable to sustain a clear intention. You have to be able to probe the rationale for changes. People are certainly entitled to change their mind for various reasons, but they need to be able to tell you that in a clear and rational way. They have to be able to, in a conflictual environment, at least explain to you that they have an understanding of what the emotional milieu is, what the conflicts are. And if they can, they're capable. As experts, we look for other evidence of psychiatric or neurologic disorders, the presence of a dementia, and that's important for the courts to understand, and that's where medical experts can help the courts understand behavior and thinking and odd behavior, inconsistency, if we can help the court at least understand that there is or is not evidence for a mental or neurologic disorder present. Clear and consistent, I put a lot of value on that clinically. That capacity is associated with clarity, with consistency. And then this last caveat, which is beware of social graces. There are many people who are significantly impaired cognitively with dementia, Alzheimer's disease, who can appear on the surface to be intact if they have their social graces. And unless you probe, and if you just engage in superficial banter, the average person wouldn't know that this person was impaired. So that's an important caveat. Let's go next. So what do we look for? When you're doing an assessment, we look for prior wills, legal documents. We look at medical records, informant reports. That's the kind of material that a careful assessment of capacity. You're going to get me a glass of water? Yeah, you can tell that I'm dying here. Oh, there's one right here. Oh, okay, that's good. That's all in here. I think I'll be there. Archie drank from this? Right.
You got to be careful because sometimes it's rules.
All right. Alzheimer's disease can sometimes be contagious. All right. Let's go on to the next one. I won't bore you with the details of what we look at, but there is I said that the contemporaneous documentation is a powerful defense, and when a lawyer documents it, that can be a very good defense. But I grew up with this dictum, cobbler ply thy trade, and I find that some lawyers have now taken to doing their own mental assessments, including mini mental state exams, and a little knowledge can be dangerous, so you have to be careful about that. But the sort of things that we probe in terms of brain functions, what you need to have the requisite capacity, meaning understanding and appreciation, as I've talked about, you have to probe orientation, memory, their perceptions, reality testing, the presence of delusions. But more importantly, in subtle cases, as most often the case, is this last area of mental function known as executive or frontal functions. The front part of the brain, the frontal lobe, which subsumes what we call executive brain functions, is the part that distinguishes us from other animals. And that's the part that can be subtly impaired and affect the following abilities in the next slide. Things like impulsivity, the capacity to think in an abstract as opposed to a concrete manner, the capacity to plan ahead, to understand and appreciate consequences. That's all part of frontal functioning. And you can theoretically be fully oriented and yet have impairment of these functions. Judgment. And you can understand why this is important, particularly in a conflictual or complicated environment where you have to sort out competing claims, where you have to be able to think in a slightly abstract way. You have to use judgment. You have to plan ahead and think about what the consequences are of a complicated distribution. Those are the sort of things that a good capacity assessment would probe, or should probe. Let's go on. Now, you've heard about some of these, the mini mental state exam or the Folstein exam. I don't know how many of you have actually heard about these, but I find that there are some lawyers. These are the tests that medical experts and neurologists will use to probe the sort of things that we've just been talking about. Let's go on. And just now, finally, a word about undue influence and its relationship to capacity. And here there are international differences. The doctrine of undue influence, in many jurisdictions, it's felt that we have this, that there is an allowance to invalidate a will on the basis of undue influence because society and the courts want very much to preserve people's autonomy to distribute their assets in the way they want. So to overrule one's wishes with respect to a state is taken very seriously, and we want, if at all possible, to preserve that principle, that you can do what you want with your assets. So many jurisdictions allow for a low threshold of capacity, and yet will use the doctrine of undue influence to override or invalidate a will. In England, it's almost impossible, according to my colleagues in the United Kingdom, to use this doctrine. Whereas in North America, it's actually considered much easier to invoke that. The reason is that in English case law, undue influence used the principle of coercion. You had to prove undue influence, you had to prove that the testator or testatrix was coerced in some way, confined, threatened. Whereas in North America, a broader notion of subversion of will, that is, that the will was taken away from that individual, and it doesn't have to be by coercion. And I'll show you what I mean in this next slide. Let's just go to the next one, sorry. I won't go through the indications, but this is a similar kind of interrelationship between undue influence, which is in the red, and not undue influence. So I think there's a generally accepted doctrine that it's not immoral or illegal to try to influence a testator to distribute their assets in a particular way. A child can importune their parents, say, look, you've got to look after me, please give me. That's not necessarily wrong or immoral. However, if that same parent is compromised, then you're at risk, again, of moving into the red. So, somebody with a high level of cognition or emotional stability, a normal, perfectly normal person, can be influenced without it being undue, and even to a high level of influence. Although ultimately all of us are potentially vulnerable if the coercion, if I was taken into a room at gunpoint and somebody said, Schulman, I want you to change your will and give it all to me, at that point I would do that. So even though let's assume for the moment that I'm intact, I could be unduly influenced, but only through coercion. If, however, I suffer from dementia, or I have a major psychiatric disorder, and I'm down here on the cognitive or emotional stability scale, it would probably take a lot less influence to move into this. So let's take the extreme example of a severely demented person. Although in that case they would probably be considered incapable on a testamentary basis. But somebody in a moderate level who would otherwise be capable, it wouldn't necessarily take coercion, but persistent influence to subvert their will. And that's a principle from a clinical point of view that we have put forward. Now, whether the courts actually accept that principle, I don't think has ever yet been formally demonstrated. But that's the issue of vulnerability to undue influence. So finally, in the last slide, let's go to the last slide. Just to review, when it comes to capacity and issues of capacity, this is the ultimate question that needs to be answered. Does the testator have the task-specific capacity, that is understanding of relevant facts, appreciation of consequences, in the context of their specific environment to execute the will? So it's both the specific task and the understanding of the environment in which they find themselves that ultimately determines capacity. Thank you very much.